Hello, 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 everybody, and welcome. So, we got some new stuff that has come out regarding the Bryan Kohberger case. I'm going to wait for a few people to get in before we start so we don't have to keep repeating ourselves. But there is Nana. Hello, Nana. Good morning. Good morning. Good morning. Thank you for being here. So, as we're waiting for people to jump in, you guys, here's the book we're going to be giving away next week. So you can read what's going on below the chat here, right there, below the screen, right down here. For every $5 super chat, you get your name on the wheel. You can enter more than once. And we will be drawing for this book live after I cover the change of venue hearing on the 29th. So if you do want this book, $5 super chat, get your name on the wheel. We'll spin that wheel once the hearing on the 29th is completed, and you'll be able to see the live draw to see who wins. Kate Bell, missed you Sunday. Good to hear your voice. Good to hear you too, hon. Good to see you too. Plucky little poppet. Good to see you. Happy Tuesday. Thank you, thank you, thank you, you guys. Yes, hit the like on the way in. Also, along with the book, I just completed this little guy. I'm going to frame him out. And I know a lot of my subscribers are in the US, so I decided I would do this. And I will frame it all out. It's going to look really nice in the frame. If you haven't seen over on Dolly Vision, I sent him one with the turtles coming out of a hole for Turtle Island. I just love that he's doing that Turtle Island thing. So I sent him one. But anyway, it's going to be framed out like that. Like I said, I just finished it. I don't know if you can see how sparkly this is, but I don't know if the camera is doing it justice. But once I get it framed out and everything, it's going to look really good. It's going to really pop with the black around it. So I'm going to include this too, framed with whoever wins the book. So for a $5 super chat, you get a chance to win the book. And I am going to have this framed and put in with that for the winner. I'll sign the back of it. See, just completed August 19th. I wrote it on the back. So that's going to be nice. Hopefully I'll get it framed sometime this week. So Sunday, when we do the mini reads and that, I'll be able to show you this all framed. So that is going to go in with the book. I guess we can just leave it there. Oh, thank you, Nana. I've been working on so many of them, you guys. It's really slowed down in the true crime community. So I've had a chance to be able to catch up on some of my diamond paintings, that catching up on the private reads also. So, all right. So let's get into this. Okay, how am I going to make this bigger? Hang on a sec, you guys. There we go. That's a little bigger, and then you can still see the book and the diamond painting that I'm going to be giving away also. Okay, so let's go over this. It's going to be a long one, you guys. We can discuss in the chat what you guys are thinking about this. The defense has put a motion for change of venue. Next Thursday, I will be covering that live here, right here on this channel when they have this hearing. There's a few other things that are going to go on in that hearing too, but the big thing is the change of venue. There's going to be a lot of arguing about it. And once that hearing's done, we're going to do the draw for this here. Give me just a sec. Give me about 20 minutes. Okay, so with that being said, the defense has replied to their motion to change venue. Now, I kind of agree with this, but we're going to go through it here, and I'm going to see what you guys think. I do still have my cough, so if you see me mute myself, it's because I'm going to cough. I do have my trusty Tim Hortons coffee here too. So I'll be drinking that as we go. Okay, so can you guys see my pointer? No, you can't. Okay, let me stop for a minute. Let's reshare this a different way. Entire screen, maybe. Now you can see my pointer. Good show. Good going, Willow. Get with the program here. All right, so here is the state's objection. And like I said, I haven't even read through all of this, you guys, so a lot of it's going to be new for me too. I read through the first maybe 2 pages. So comes now the state of Idaho by and through Latah County prosecuting attorney and objects to the defendant's motion to change venue. And it's crazy. They're what they're asking for in their change of venue is just nuts. You're going to hear about it here, right here. The defendant has filed a motion to change venue, requesting that the trial in this matter be moved from Latah County, where the offenses took place, to Ada County, some 300 miles away. 300 miles. So can you imagine that, you guys? 300 miles away. I'm assuming that you're for your highways and stuff, it's like 60 miles an hour you're allowed to go. To drive it, it's like a 5-hour drive, 6-hour drive each way. So, and a lot of their expert witnesses, where the autopsies and everything were done, all those people would have to fly in. If they moved it to Ada County, they would have to fly them in, motel rooms, rental cars, all this stuff. It's like all the family members, anybody who's connected to the case would all have to drive. Well, they would be flying because there's no way you can go 6 hours. You know what I mean? But anyway, if they do decide to go out, it's going to be 2 to 3 month trial. Can you imagine having to rent a motel room and everything for that amount of time? So they're saying it's absolutely ridiculous. But let's read what they have to say. They have a lot of good points. To support his motion, he conducted a survey of prospective jurors in Latah County, Ada County, Canyon County, Bangkok County. But far from demonstrating that Latah County jury pool has been uniquely subjected to an utterly corrupted environment, as defendant argues in his brief, the data show that persuasive and wide-ranging coverage of this case throughout the entire state of Idaho has led to high case recognition among survey respondents across all 4 surveyed counties. The court should decline defendant's invitation to parse and split hairs over an incomplete database to reverse engineer a transfer to Ada County, which, according to the defendant's own experts, has received the second highest amount of media coverage. Okay? The defendant's own experts say that Ada County has received the highest amount of media coverage, but that's where they want to move it. They're saying that they want it out of Moscow and out of Latah County because of the media coverage. But Ada County has the second highest amount of media coverage in the state, and where a statistically greater number, albeit slight, of the survey respondents familiar with the case believe the defendant is guilty. So it doesn't matter where they did this, Ada County, all these other counties where they did this survey. It's pretty equal of how many people thought he was guilty, whether you were in Ada County, Latah County, or what was the other ones? Canyon County, Bangkok County. Basically, they all believe he's guilty, a great number of them. So those familiar with the case in all those counties believe he's guilty. The court should deny the defendant's motion and instead focus on crafting remedial measures to ensure that a fair and impartial jury can be seated in Latah County. The argument: although the government generally must prosecute an offense in the county where it occurred, a court may change the venue in 2 limited circumstances. I'm not going to read all these sections and everything. First, a court must change venue to another county if the court is satisfied that a fair and impartial trial cannot be had in the county where the case is pending. Second, a court may, but is not required to change venue for the convenience of the parties and in the interest of justice. In this case, the defendant asked the court to change venue on both bases for the following reason. The defendant has failed to show that either of these circumstances apply. The defendant has failed to establish that a fair and impartial trial cannot be held in Latah County. The defendant has argued that due to persuasive publicity in this case, a change of venue is appropriate. Hello, Summer. Defendant further claims that the atmosphere in Latah County has been utterly corrupted by media coverage. It is undisputed that the defendant has a constitutional right to a fair trial with a fair jury, a panel of impartial and different jurors. On a change of venue motion, it's defendant's burden to show a reasonable likelihood that pretrial publicity will deprive him of a fair trial. Oh my God, this cough is horrible. However, where pretrial publicity is at issue, a presumption of prejudice necessitating a change of venue applies only in the most extreme of cases. The mere fact that the crimes reported by the media are gruesome or memorable does not render the publicity inflammatory to the extent of requiring a change of venue. And like their own surveys showed, even where they want to move it 300 miles away to Ada County, people there that know of the case basically believe he's guilty. So it doesn't matter where they move it. You know what I mean? Hello, Jeff H. Good to see you. Summer Dawn, good to see ya. Kate Bell, good to see ya. Okay, did I read this part? The United States Supreme Court has also explained that juror impartiality does not require ignorance, which means it doesn't mean that somebody can't have ever heard about the case or that they didn't hear about the case, right? In determining whether pretrial publicity has risen to a level that justifies a change of venue, Idaho's appellate court looks to a series of factors. The accuracy of the pretrial publicity, to the extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence, the number of articles, whether the jurors were so incessantly exposed to such articles that they had suddenly became conditioned to accept a particular version of the facts at trial, and the amount of time that has passed between the coverage and the trial. The United States Supreme Court has held that only in the most extreme cases is a defendant afforded a presumption of prejudice based on pretrial publicity. And it doesn't really matter, you guys. Like I said, they did their own surveys, and those surveys showed that people were just as hardcore in Ada and the other counties as they were in Latah County, right? Okay. In a bank robbery homicide, defendant afforded a presumption of prejudice where his videotaped confession during a police interrogation was aired on local news 3 times and seen by thousands. During court hearing proceedings, judge allowed unmitigated camera access to the courtroom, including the filming of jurors' faces. Wow, that's a no-no. Neither Rito nor Estes apply here. The defendant in this case did not confess to the murders, let alone on video broadcast to thousands. And it's the state's understanding that the court will not allow the filming of jurors' faces at trial in this case. Well, that's a no-no. You don't do that anyway in any state. The defendant urges this court to find that Shepard versus Maxwell, another U.S. Supreme Court case, applies here. But Shepard is wholly inapplicable to this case. In Shepard, bedlam reigned at the courthouse during the trial, and newsmen took over practically the entire courtroom, hounding most of the participants at trial. Within a few feet from the jury box and counsel table sat some 20 reporters staring at Shepard and taking notes. The Shepard court went on to explain the extreme nature of the media participation at trial. The erection of a press table for reporters inside the bar is unprecedented. The bar of the court is reserved for counsel, providing them a safe place in which to keep papers, exhibits, and to confer privately with client and co-counsel. It's designed to protect the witnesses and the jury from any distractions, intrusions, influences, and to permit bench discussions of the judge's rulings away from the hearing of the public and the jury. Having assigned almost all of the available seats in the courtroom to the news media, the judge lost his ability to supervise that environment. So the movement of the reporters in and out of the courtroom caused frequent confusion and disruption at trial, and the records reveal constant commotion within the bar. Moreover, the judge gave the throng of newsmen gathered in the corridors of the courthouse absolute free rein. Participants in the trial, including the jury, were forced to run a gauntlet of reporters and photographers each time they entered or left the courthouse. The total lack of consideration for the privacy of the jury was demonstrated by the assignment to the broadcasting station a space next to the jury room on the floor above the courtroom, as well as the fact that jurors were allowed to make telephone calls during their 5-day deliberation. So they're saying that case doesn't apply either. So they're just citing that case and what it is. This case has nowhere near the chaos presented in the Shepherd case here that they're using. So it looks like the defense is using these two cases that have been cited, and the prosecution is showing why those cases don't even affect his case, right? Because this hasn't even happened yet. What they're saying here with the news being seated next to the jury and taking up most of the courtroom and blah, 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 that hasn't even happened yet. So I don't know how they're able to try and use that for a reason to get a change of venue, unless they're saying the courtroom isn't big enough in Latah County. I don't know. But the prosecution is stating that this case has nowhere near the chaos present in the Shepherd trial. As the Shepherd court explained, the carnival atmosphere at trial could easily have been avoided since the courtroom and courthouse premises are subject to the control of the court. Here, the court has scrupulously avoided such an environment. Don't forget, the judge in this case has ruled that they are going to be using their own court equipment to show the trial. And it's going to be live streamed. So you're going to have to get it from there, right? So they're not going to have this in the courtroom because they're going to be using the court equipment. So you're not going to have all these news reporters and everything in there unless they're sitting in with others that are there to see the trial and maybe tweeting out on their computers or whatever. So I don't see how that is going to apply. Here, the court has, okay, I've already read that. The court entered a non-dissemination order early in the case, which means a lot of the facts and everything that are there. Hello, Crazy Graham. A lot of the facts and everything, a lot of the motions and all that stuff, it's all been kept secret. So I would say 80% of it hasn't been shown to us, right? So this here is keeping down what's been released to the public. So in this case here that they're talking about in the Shepherd case, it was like a frenzy of reporters and every single thing was being reported on. Whereas in the Kohberger case, that's not so because there's a non-dissemination order. Everything's being filed in secret, etc., right? So when the small press pool that was allowed in the courtroom failed to follow the court's instructions as to filming or photographing the defendant, the court disallowed any media filming, photographing, or audio recording of court proceedings. This court has repeatedly taken precautions to avoid the circus-like environment described in Shepherd, and thus Shepherd is easily distinguishable and a poor comparison to this matter. I agree. As the case law makes clear, the test is not knowledge of the case, but rather partiality. Okay, so they're stating another case here. Thus, the fact that Latah County survey respondents had the highest percentage of knowledge, well, they would because it happened there, right? And you're supposed to be tried by a jury of your peers in the place where the crime was committed. So obviously people are going to have more knowledge of it. But this is a widespread. I'm in Canada, and I know probably more than some of the people know about this case in some of these counties they're talking about, right? So I don't think this really matters. About the case compared to other counties is far less significant than the fact that Latah County's survey respondents had the least amount of overall prejudgment among the counties. So there you go. Latah County had the least amount of overall prejudgment. Whereas where they want to move at Ada County had the second highest that thought he was guilty already. Prejudgment, right? Okay, so the survey data provided by Dr. Edelman is inadequate to justify a change of venue. It is not reported how many individuals declined to take the survey, raising serious concern about non-response bias. A glaring omission in the data provided by Dr. Edelman is the lack of any information about the number of individuals who were contacted but chose not to respond to the survey. This is important because non-participation bias can change the outcome of each survey, or of such a survey, sorry. What a low response rates means for the telephone survey, Pew Research Center available at, and they give the address, what low response rates mean for telephone surveys. As of the authoring of the 2017 article promulgated by the Pew Research Center, what a name, Pew Research Center, telephone poll response rates stabilized at approximately 9% after years of decline. Yeah, it was. There was stuff in that survey that shouldn't have been in there. There was evidence that was talked about. There was theories that were talked about. So, yeah. While the Pew Research Center article concludes that low response rate does not necessarily lead to a conclusion of bias across all subject matters, low response rate can skew results in specific areas. For example, individuals with high civic involvement are overrepresented in surveys. As the Pew article explains, telephone polls generally overstate civic engagement, probably because of non-response bias. As has been established in previous work, the people who answer surveys are likely to be the same people that are involved in their community's public life. They are joiners. Such a phenomenon could easily play a role here, where at the very outset of the survey, respondents were told that they were being asked for opinions about an upcoming jury trial. This court must ask itself, would an individual who has asked for their opinion about an upcoming jury trial continue a survey if they had no opinions about any upcoming jury trials? And once the survey started, would a prudent, thoughtful, and conscientious person who is reluctant to pass judgment with limited information opine to a stranger whether they believe a criminally accused is guilty of murder? True. Hello, K. Mitch. The court should also consider the fact that while the survey respondents were told that the poll was not political or sales related, these survey respondents were never told why they were being asked questions. They had no way of knowing whether the poll was being done on behalf of the news media or a true crime blogger or for some other purpose. While they were told their responses would not be made public, they were never told whether they were being recorded. One only has to exercise common sense to see that there are innumerable reasons why prudent, thoughtful, deliberative, and conscientious individuals might hesitate to complete such a survey. The defendant's flawed hypothesis is that if 98% of self-selected group who voluntarily chose to share opinions about an upcoming jury trial have heard about the particular upcoming jury trial, then 98% of all citizens who are summoned for jury duty will also have heard about it. The court should reject this illogical leap of faith and embrace the more practical inference. It is more likely that a voluntary survey that begins by asking individuals to opine about an upcoming jury trial will overrepresent individuals with knowledge of an upcoming jury trial. The court does not have complete survey data and therefore cannot adequately compare the data among the 4 surveyed counties. As defendant acknowledges, this high-profile quadruple homicide case has captured the attention of the community, the state, the country, and even beyond the United States. I concur because I'm in Canada and I'm knee deep in this. States objecting to the defendant's motion to change venue. Motion to change venue, page 5. Given the amount of attention that this case has received across the entire state, there are 2 critical questions on the defendant's motion to change venue. The first question is whether a fair and impartial jury can be convened in Latah County. And if not, the second question is whether an alternative county would better safeguard the defendant's right to a fair and impartial jury. After all, why would the court change venue to another county that has nearly the same media saturation as Latah? Yet the state and the court were not provided a comprehensive list of every survey responses across all 4 counties surveyed. In fact, Dr. Elderman's report focused primarily on Ada County as an alternative venue, despite the fact that Canyon County and Bangkok County, the other 2 county surveys, both received astronomically less media coverage than Latah or Ada. Right? Let's see what Jeff's saying here. Thank you, Jeff, for your comment. For a defense team that was concerned about potential jurors knowing too much about the case, the survey sure seemed to run the risk of teaching potential jurors too much about the case. I agree 100%, Jeff. 100%. There was a lot of things that were in that survey that some people wouldn't have known. So you got to realize that there's a lot of people, no matter where you live, and like I said, even here in Canada, the people just aren't interested in true crime. They're not interested in criminal activity. They're not interested in hearing about shootings and this and that. They tend to sometimes just change the channel because this world has become so hostile and so unpredictable that the saturation of hatred and crime and everything else, people just don't even want to watch it anymore. A lot of people don't even watch the news anymore. So if you call somebody and they're not people that watch the news, but they've heard about the case. Oh yeah, I heard about that. There was like 4 college students, their lives were taken and they got the guy. Maybe that's all they knew about this case. And then you get them asking all these questions that they put in there. Now they know more, right? So to me, it's you're in bubbling water. You know what I mean? Hello, Cat H. There she is. I don't watch the news anymore. I watch it all. Thank you. So with these 2 other counties, Canyon and Bangkok, both received astronomically less media coverage than Latah or Ada. Ada was even higher in publicity than Latah. Why are they pushing for Ada County? There's got to be a reason. If they are going just by their survey, then it should have been Canyon or Bangkok that was chosen because they received astronomically, not just a little bit, astronomically less media coverage than Latah or Ada. And the fact that Ada is 300 miles away. An example of the incomplete data provided from Canyon and Bangkok counties is found on pages 50 and 51 of Dr. Elderman's declaration, where he reports that in Canyon County, approximately 90% of the jury-eligible population there had read, seen, or heard about the case, and 51% followed the case somewhat or very closely, and that in Bangkok County, approximately 84% of the survey respondents recognized the case and some 14 percentage points lower than Latah County. Just 45% of the survey respondents followed the case somewhat or very closely. There you go. Right? So both lower than Ada or Latah. But they've chose Ada, which had one of the highest amounts of saturation. However, when Edelman discusses the Ada, here we go, the Ada County, speak clearly, Willow, and slow down. Let's try that again. However, when Edelman discusses the Ada County survey respondents, he reports that while Ada County had a 93% recognition rate, there were important differences between the Latah and Ada County jury pool. Ada County residents are far less invested in the case, and only 15% reported that they followed the case very closely, compared to 29% of Latah County residents. That's still a low percentage, even at 29%. Not enough to move it out of Latah County. It's unclear why the court was provided that the statistical number of survey respondents who followed the case very closely in Ada County. Yet in Canyon and Bangkok County, the somewhat and very categories were collapsed, creating a larger percentage. This piece of contest, and that's what they did, they grouped these two together with somewhat and very much so following it. They grouped them together so they had a higher percentage. Whereas in Ada and Latah County, they separated them to, this is the percentage that somewhat, and this is the percentage that very much, very closely followed it. Well, you can't group this very closely and somewhat together in two counties and not group those two very same statistics together for the other two. The surveys have to be exact. You can't deviate from how you're calculating percentages in one county but not the other. You can't group somewhat and very closely together in a county to make it look like, there's far more in that county that, anyway, I need more sleep. This piece of contest is especially concerning given that the defendant is advocating specifically for a venue change to Ada County. Why? What is Ada County? Does Ann Taylor have friends? Let's just say that. Entertainment purposes only. Don't come for me. I'm not rich. Don't sue me. But does she have friends there? Does she have friends in Ada County? Does she have strings she can pull in Ada County? Why Ada? Especially when Ada had one of the highest amounts of people who knew about this case and thought that he was guilty. Why? Why would you want it there? They did provide surveys, but they were incompleted surveys. Like all the information from the surveys wasn't there for the other two counties. Despite the fact that Ada County has a slightly higher prejudgment rate than Latah. So there's more people in Ada County that think he's guilty than in Latah County, and a higher percentage of case recognition. So Ada County has more people that think he's guilty and a higher percentage of case recognition than Latah County. But you want it moved to Ada County? It doesn't make sense. There's a reason why they, right here, advocating for Ada County. There's a reason. We got to figure out what that reason is. I'm going to dig deep into this. And you guys that are in the US, because it's hard for me to get a lot of stuff from Canada, thanks to Justin Trudeau, our prime minister, who has blocked us. Like on Facebook, I can't share any news articles. I can't look up any news articles. He's blocked us a lot from being able to even get news articles, even in our own country. It's ridiculous. He needs to go. He needs to go. Justin Trudeau needs to go. Anyway, Okay, so despite the fact that Ada County has a slightly higher prejudgment rate than Latah and has a higher percentage of case recognition, 93% than either of the two alternative counties, Canyon 90%, Bangkok 84%. So Canyon and Bangkok are way below Ada County. Canyon slightly, Bangkok almost 10% lower. Nana says, what does the phrase mean, being in bubbly waters? I forget what I used that for. I forget why I said that. But usually it means like you're in a, some say slippery slope. I forget what I used it for. I always wonder where Bubbly Waters, the YouTuber, got her name. Oh, there's a Bubbly Waters. Her theories are so far-fetched. I thought maybe she was high, and then maybe her name. Aha! Oh, Jeff, that's funny. Okay, so let's get back to this. Additionally, Dr. Eldman discussed the phenomenon of minimization effect, which is when a prospective juror attempts to minimize the full extent of their exposure to pretrial publicity. However, his discussion about the impact of this phenomenon on the actual survey respondents in this case was limited solely to Latah County. See, prejudice against Latah County, like he is doing everything to keep this, like, let's drive Latah County into the hole, into the hole, into the hole. We can't have it here. We can't have what? But you can't just use that phenomena to try and get Latah County out of the picture. You got to use it across the whole board. Anyway, I haven't read this far yet, so this is the first time reading this far, you guys. Summarily, as discussed in more detail below, nowhere in the survey report is there a mention of answers provided by Canyon County or Bangkok County survey respondents about the two most potentially prejudicial and inflammatory pieces of media information addressed by the survey. Rumors that the defendant had stalked one of the victims or followed them on social media. So yeah, so what? Nowhere in the survey report is there mention of answers provided by Canyon County or Bangkok survey respondents about the two most potentially prejudicial and inflammatory pieces of media information addressed in the survey. Rumors the defendant had stalked one of the victims. Oh, they never mentioned that in some of the surveys. Or there's probably no report of their answers because they probably didn't mention it. Okay. In an environment where the court has limited data and where the defendant is asking the court to move venue to a county with a slightly higher prejudgment rate among surveyed respondents with knowledge of the case, these types of omissions make it impossible for the court to make an informed determination whether to move venue at all, much less to move it specifically to Ada County. Right? They're pushing for Ada County for some reason. The majority of the survey focused on prospective jurors' knowledge of information already within the court record and admissible at trial. Defendant argues in his brief that this matter is an extreme case justifying a change of venue due to the continuous nature of media coverage, often inaccurate and misleading, the impact of the media coverage, and the small size of the community. Wow. But Idaho's appellate courts have repeatedly held facts are prejudicial when they are beyond the scope of admissible evidence or inaccurate. So, when reviewing the nature and the content of the pretrial publicity, this court is concerned with the accuracy of the pretrial publicity, the number of articles, and whether the articles will condition the jurors to accept a particular version of the facts at trial. But they question them equally across these four counties. Well, they were supposed to. The survey is supposed to be the same for each county. You can't have one set of questions for one county and another set of questions for a different county and expect to be able to balance those or find a determination when you have two separate surveys asking two separate sets of questions, they're not going to be answering equally, because that's why you have the same survey across all four. And it seems to me, by what they're saying here, either the information wasn't submitted to the court, or they didn't ask certain counties certain questions. That's what I'm inferring by this. So, qualitatively, the courts must be concerned with news stories and editorials that are inflammatory, inaccurate, or beyond the scope of admissible evidence. During the course of Dr. Eldman's survey, respondents were asked whether they had read, seen, or heard about a series of factual information items related to the case. The majority of these items, that cell tower data, showed that the defendant was near the victim's home several times in the months before the murders, that a knife sheath was found at the murder scene, that DNA found on that knife sheath came back to match the defendant, that the defendant drove the same type of vehicle seen in the neighborhood of the murders, that the defendant was arrested at his parents' house in Pennsylvania, that the defendant has stated he was out driving alone on the murders, are part of the court record and admissible at trial. Only 3 of the questions asked were not part of the court record. These questions were: have you read, seen, or heard if university students in Mocow? What the frig is this? You guys know me. See? This is one of my biggest pet peeves. Like when I was in the law office and I was reading over documents, this was one of my biggest pet peeves, especially in a high profile case. Spell check. Check your work before you file it. Have you read, seen, or heard if university students in Mocow? Oh my God. It's supposed to be Moscow. And their parents lived in fear until Bryan Kohberger was arrested for the murders. Have you read, seen, or heard if Bryan Kohberger stalked one of the victims? Have you read, seen, or heard if Bryan Kohberger had followed one of the victims on social media? Like, why would you put these two? This should have been one question. Have you heard if he'd stalked or followed one of the victims on social media? That's what should have been asked. But they're putting in as much as they can. According to Eldman's report, 45%, less than half of Latah County residents surveyed responded yes when asked if they had read, seen, or heard that the defendant stalked one of the victims. The report did not indicate the response rate for the other counties surveyed. See, you can't do that. You have to give, and this is why I say, did they use the same survey across all 4 counties? If they didn't, this all should be thrown out. Because if you're saying 45% of Latah County residents responded yes, okay, what did the other 3 counties respond? There's nothing from the other counties by the sound of this. The report did not indicate the response rate for the other counties. That's not right. Miss Always Right, Ryan. 2 years and 1 month. I think it should stay where it is. Fly put up jurors all over Idaho. Yep. That way only about 20 to 25 people would need to travel. Yes. Yes, congrats, Miss Always Right, Ryan. Woohoo. Much love. Much love. 25 months. Wow. Okay. The report did not indicate the response for the other counties surveyed. Similarly, 45% of Latah County residents responded yes when asked if they had read, seen, or heard that the defendant followed one of the victims on social media. Dr. Eldman reported that only 35% of Ada County respondents reported having heard this information, but did not report on the responses from the other 2 counties. Like, what the hell? Why aren't you giving the percentages for each question asked from each county. Here's the question. Here's the county. What's the percentage in this county, this county, this county, and this county for that question? What percentage answered yes? But they're only giving some. And it seems like they're only giving some to compare. So it looks like Ada County's the best spot. You know what I mean? So like here they're saying 45% of Latah County residents responded yes when asked if they had read, seen, or heard that the defendant followed one of the victims on social media. So 45% of Latah County heard that. And they're saying only 35% of Ada County respondents heard that. What if, and they're doing this to show that, look at, there's only 35% in Ada compared to 45% in Latah. Okay, well, what about the other two? Canyon, maybe Canyon County, nobody heard of that. 0%. Or the other county, what was it, Banyan or something like that? Maybe Banyan only said like 3%. Well, they're not going to use those percentages because it's going to look bad for getting this transferred to Ada County. But look at Ada County's lower than Latah. They're pushing for Ada County for a reason. Okay. And see this, but did not report the responses from the other two counties. Why? I bet you they were like in the very low percentages. Maybe 10%, maybe 5%, maybe none of them heard it. You can't just give selective analysts. You got to give it all for each question for all four counties. I think this is where Ann Taylor is being sneaky as and shady as F. And if you got to be shady like this and try and slip this by, like the prosecution or us for that matter, if I'm seeing it and you're seeing it, you don't think the prosecution's going to catch it? You know what I mean? Do you think you're that sly that you're just going to slide that on by? And why are you doing things like this if you believe your client is not guilty? You only get shady when you know he's guilty and you're doing everything to try and slide stuff by people. Slither like a snake. Right? Okay, where was I? Okay. As to the question whether individuals had read, seen, or heard that the university students and their parents lived in fear until defendant's arrest, overall response rates were not provided for any county. Because probably nobody ever said it or could agree with it. They're trying to put things in here that is going to boast, oh my God, look at that. Like everybody was in fear. No, they weren't. Did you see what was going on in Moscow after these murders? It's almost like people were, like within a week, people were back to normal business. In any event, the substantial majority of the factual information asked of the survey respondents was not beyond the scope of what would be admitted at trial. Most of the items were contained within the court record. As to the prejudicial items related to rumors that defendant had stalked one of the victims or followed any of them on social media, less than half of Latah County survey respondents reported even hearing of it. The data provided to the court demonstrates, if anything, the majority of Latah County survey respondents had not heard the most prejudicial and inflammatory information pieces outside of the court record that Latah County residents who have heard about the case were overall statistically less likely to prejudge the defendant. You think the back of Anne's mind, she's like, damn, this was some awesome investigation. Oh, yeah. She's scared. You don't get shady and start trying to pull stuff like this unless you're in fear. The court should decline the defendant's invitation to disregard long-settled precedent establishing voir dire as the proper procedure for addressing bias. Absolutely. That's why we have voir dire. The survey relied upon by the defendant did not even ask respondents the most crucial question of all, whether they could set aside their biases and base their decision only on the evidence at trial. Right? Instead, the defendant and his expert asked this court to simply assume that the survey respondents, and by extension, all potential jurors in Latah County who have been exposed to the media information about this case, are incapable of setting their biases aside and serving on a jury. So in other words, you're saying that the people that live in Latah County are just ignorant, rude, won't follow the law, have no compassion, have no smarts, have no, you calling them all stupid? What the fuck? Right? What's this defense team saying here? Because all the numbers are higher in Ada County. Ada County is more prejudicial against your client than Latah County. And you won't give us the statistics for the other two counties, which were probably even lower than low could be, because then it would have been an option for either Canyon or the Buchanan or whatever it is, if it was going to be moved out of Latah County. It wouldn't go to your Ada County. Why are they pushing so hard for Ada County? There's got to be a reason. I want to dig into this. I don't know how far I'm going to be able to get, but if you guys are good little sleuths, like I know 99.9% of you are, because we do get that 0.1% trolls come in sometimes. So you guys do some sleuthing. Check out connections Ann Taylor has to Ada County. I'm wondering, why do you want to move a trial to a place that looks like, by your statistics, that there's more people there that are going to find him guilty than in Latah County or one of the other two counties? Why are you pushing for Ada? There's got to be a reason. There has to be a reason. In Dr. Edelman's declaration, he argues that a juror professional ability to be fair and impartial should not be taken at face value in cases where there's a substantial prejudicial pretrial publicity. What? He argues that a juror's professed ability to be fair and impartial should not be taken at face value? What? So, what are you saying here? That a juror's professed ability to be fair and impartial should not be taken at face value in cases where there's a substantial prejudicial pretrial publicity. What? So you're telling me when you're in voir dire and you've got a potential juror looking at you and saying, yes, I can put my preconceived notions or thoughts or convictions aside and go by what's presented at trial. I can put that aside and be fair and impartial. You're saying none of them should be able to be taken. You'll never get a jury. How can you possibly get a jury if this doctor is arguing that a juror's professed ability to be fair and impartial should, not be taken at face value? What? Wow. That is degrading. Similarly, Professor Scott Sundby argues generally that small town residents where a crime is committed cannot be impartial jurors and will go into the proceedings with a thumb on death's side of the scale. How prejudicial. Look at how they're judging these people of Latah County. If I lived in Latah County and was reading this, I would be outraged. You're saying generally small town residents, try that in a small town, bud. You ever hear the song Professor Sunby? Try that in a small town. Oh my God. Small town residents where a crime is committed cannot be impartial jurors. If I lived there, I would be losing my shit. So what are you saying? We're all ignorant, biased, non-prejudicial? What? We're prejudiced? Is that what you're saying? Sunby asserts that there are two distinct dangers to holding the trial in Moscow. First, Sunby argues jurors will be aware of the community outrage and, as a result, might fear being outcast if they fail to return a death sentence. In support of this assertion, Sunby provides a single example: the Arkansas case of Bobby Ray Fretwell, whose execution was commuted after a juror came forward and admitted that he had voted for the death penalty for the sole reason that he feared being ostracized in the hometown he shared with Farrell's victim. What? That he'd be ostracized? So, I don't get that. What? You can be ostracized either way. It's 50-50. You have people for, and I'm sure Bobby Ray Fretwell had people for and against him. And generally in especially smaller towns, there's going to be a divide. Doesn't matter where you go. There's going to be a divide. There's going to be, look at what's going on right now with the, what's her name? Karen Reed. 50% of people think she's guilty. 50% say she's not. There's a 50-50 in any case, regardless. So you fear being ostracized for not agreeing to the death penalty, but you could have been ostracized for not agreeing to it too. It's 50-50. I don't get it. Death row inmates spared after juror makes plea. Setting aside the obvious issue with asking this court to base a legal decision on a single news story involving a nearly 40-year-old case that is not binding on this court, there is a glaring distinction between the Fretwell case and this case, the advent of social media and the internet. Assuming the 1984 homicide went to trial in the middle of the 1980s, it's virtually certain that media coverage was more localized to the community rather than spread out across the state. This is true because internet really didn't take off until the early 90s, where everybody started getting a computer, and it was like $3,000 to get, AOL, you know what I mean? To get a computer with that big, huge 200-pound screen. You know what I mean? And the most you could save on your computer was maybe a few hundred pictures before your RAM was full. Remember those computers that first came out? And dial up, ding, 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 as you're trying to dial up. A lot's changed over the years. But I do believe it was the early 90s that internet really gained speed. And it was only people of higher incomes that could even afford, even if you could afford to get a computer, you couldn't afford the internet bills because it was like, what, $1.99 a minute or 5 minutes away. It was astronomical. I know that. So thus the judge had even been asked to change venue in that case. It is entirely likely that in the absence of pervasive media coverage in a different county may well have had a population that had largely not heard of the case. But you're asking I'm going to go with this argument right here. They are asking to move the case out of Latah County to Ada County, to a county that is higher in percentage that have heard about the case and think he's guilty. Make it make sense. There's more people that are prejudiced against Bryan Kohberger in Ada County than there is in Latah County. Your statistics. Make that make sense. Let's move it to where more people think he's guilty. What? It doesn't make sense. Oh, and never mind about the other two counties. They really don't matter. Why? Because they were on the lower end of the scale. That would have been better options if the trial has to be moved. There's a reason why they want Ada County, you guys. Mark my words. We're going to have it here on record here. There's something going on why they want this moved to Ada County. She has a street named after her there? Serious? We got to dig into this, you guys. That's your job. That's your job. You guys got to dig into a connection with Ann Taylor and Ada County, especially court personnel, stuff like that. A lot of people are saying, well, no, we don't want it moved to Ada County because then, or see, here's an example. You got 50% saying, yes, let's move it to Ada County because you know what? We're going to get a new judge. We're going to have new prosecutors. No, that's not how it works. If you move the case from Latah County to Ada County, the prosecutor, the judge, the clerks, everything go with them. It's going to be the same judge, the same prosecutors there. The only difference is it's being held there instead of there. So there's a lot of people that, and I've read some comments from these very people. Oh, the prosecution is trying to pull this and trying to pull that, and they don't know what they're doing and this and that. Those same people are saying, yeah, I want it moved to Ada County because then we'll get a new judge and prosecute. And I just sit there and look at the screen like, you guys are idiots. You're an idiot. Stop trying to look smart when you're not. Because the judge, the prosecution team, the defense team, the clerks, everything go with the case when it's transferred to a different county. That's why I always tell people, like, if you don't know what you're talking about, don't try and talk about it to look smart because you end up looking so silly. Okay, that simply isn't the case in this matter where a significant number of individuals in every county surveyed were familiar with the case. Thus, it is a poor analogy that has no legal or factual relevance to this court. I agree. Secondly, Sunby argues that the homicide of the University of Idaho students created a uniquely traumatizing effect on the city of Moscow, effectively rendering potential jurors victim once removed. In support of this assertion, Sunby offers another faulty analogy, claiming that trying this case in Moscow would be a tantamount to allowing a guard who worked in the same prison to serve on a jury where a defendant was on trial for the murder of a prison guard. No, it's not. How can you make that analogy? You know what I mean? A guard that works at the prison where the guard was killed is totally different than living in a county where kids were killed. Totally different analogy. It doesn't even make sense. Like, come on. But that analogy is flawed because it does not take into account the court's ability to convene a large enough jury pool to prevent anyone with such a close connection to the case to sit on the jury. Right. The close connection here, a guard serving on a jury where another guard was killed. No, that's like a cop. That's like you serving on the jury. Like you get called somewhere, you and your partner, and your partner gets shot and killed by the criminal, and then you're on that jury for that criminal no, it's too close. No, you can't do that. But take that same analogy and like, okay, now the people of Latah County can't serve as jurors because that cop lived in Latah County and was a Latah County cop. What? Doesn't make any sense. Unless there's a very close connection, this is craziness. Similarly, after arguing that exposure to media creates biases that are different to overcome, Dr. Amani L. Ali, oh my gosh. Dr. Amani, that's what we're sticking with it. That's it. Yeah. My decision. Don't judge. Concludes that venues should be moved outside of Latah County. Dr. Amani specifically argues that even extended voir dire by seasoned attorneys does not specifically mitigate pretrial publicity effects despite its other potential benefits. Dr. Amani, take a pill, doctor. Doctor, eat your apple today. Eat your apple. Okay? This can't be guaranteed anywhere. We've had cases where jurors lied through their teeth, no matter what county they live in. Because she says, this doctor concludes that venue should be moved out of Latah County, and she specifically argues that even extended voir dire by seasoned attorneys does not specifically mitigate pretrial publicity effects despite its other potential benefits. That can happen anywhere, not just Latah County. You can move it to Ada County and voir dire there and get the same exact problem. Extended voir dire by seasoned attorneys does not simply mitigate, oh my gosh. Don't make me repeat it. Anyway, another idiot. The problem with the defendant's experts, however, is that their opinions are directly contrary to the law. Ding, ding. The United States Supreme Court and Idaho's appellate courts have repeatedly held that a prospective juror may remain on a jury panel if a trial judge is persuaded that the juror can set aside their initial impressions and render a verdict solely on the evidence presented at trial. And to accuse any potential juror of not being able to do that if they've said that they can do it is total disrespect. This defense has not only disrespected the people of Latah County, they're prejudiced against them. Remember what they said up here? When they said that they would be lying if they said they could put their thoughts in that aside. That you can't take that as fact. So this is just more. Oh my gosh, we got tons more. Okay. As at the same court explained in Haddon, it will only be the commencement of voir dire that the court and the parties will be able to determine if the prospective jurors have formed an opinion based upon adverse pretrial publicity. You don't know what these jurors are going to say until you get into voir dire. So to prejudge them, you're prejudiced. Right? Only then can the court determine whether the atmosphere of the court will be so utterly corrupted by press coverage that an unbiased jury cannot be found. So, with that being said, they want an unbiased jury. But you want to move it from Latah County to Ada County, where Ada County, there's more percentage of people that you surveyed in Ada County that think he's guilty than in Latah County. More people in Ada County think he's guilty than think he's guilty in Latah County. Make that make sense. Thus, as the state has previously argued, even if the court determined that a change of venue would be necessary, the only appropriate way for the court to do so would be after commencement of voir dire. Exactly. You're just automatically judging, which you're asking these people not to judge your client before they hear the evidence, but you're prejudging these people of Latah County before they even have voir dire. Before they can even be asked anything, you've already prejudged them. That's sick. Shame on you, Anne. The court can fashion remedial measures for jury selection short of changing venue. Because the court has not been presented with evidence that a jury pool in Ada County would be any less likely to prejudge a defendant than the one in Latah County, the best way to ensure that the defendant gets a fair trial is to safeguard the jury selection process. Just sent you a screenshot, but I'll send more if I can find. Okay, thank you. First, the court can convene a large jury pool. As noted elsewhere in this brief, if the court were to summon 1,800 jurors, only 1 in 100 would have to be chosen in order to select a jury of 12 plus 6 alternates. Next, the court could send out questionnaires to each of the jurors to gauge knowledge of the case, media exposure, biases, and other views. The court could then allow the parties ample time to review each questionnaire, and the parties could then confer to discuss whether they had reached any stipulations as to disqualifications for cause. They're going to just say, "Oh, we've got cause for all of these people." After that, the court could take up the issue of any disputed jurors and determine whether to dismiss those jurors for cause. Then those jurors whose questionnaire passed initial review could be called back to the courthouse for actual voir dire. That's how generally it goes. I don't know how they do it in Idaho, but that's how generally it goes. They send out these questionnaires, and you gotta, have you ever been charged? You have a criminal record? They ask all kinds of questions, right? And if you have a criminal record or you've had certain charges that are in the States, I guess felonies, stuff like that, you're automatically out. You know what I mean? So they do that here in Canada too. So if your questionnaire comes back good, like you've never charged somebody, you've never been involved in domestic disputes, you've never been charged with assault, stuff like nobody in your immediate family's ever been charged with this kind, your questionnaire comes back good because you got to send it back to the courthouse. I know I've been called for jury duty. I don't know how many times, but anyway, then they go over your questionnaire, and if everything is in order, then you're put on the jury list to be called in for voir dire, where you're then grilled. The court could also allow a detailed individual voir dire outside the presence of the other jurors, which would address concerns outlined by Dr. Edelman in his report, explaining that research shows that prospective jurors are more likely to be forthcoming and candid outside the presence of other prospective jurors. If the court were inclined to allow the trial to be live streamed, the court would make the exception for individual voir dire and disallow any recording of the individual voir dire to ensure that each juror being questioned would be maximally incentivized to freely and candidly any questions asked of him or her. Oh gosh, here comes that rain again. Yes, I agree. I don't care if I see voir dire or not. Be fair to these prospective jurors, treat them with respect. And if that means that we don't get to see voir dire, so be it, right? Even if the court were to find that a fair and impartial jury cannot be impaneled in Latah County, the court may impanel a jury from a neighboring county rather than moving the trial 300 miles south. Right. Even if the court were to be persuaded that a fair and impartial jury could not be impaneled in Latah County, the court can rely on Idaho Code 1918-16 and draw upon a jury pool from a neighboring county to invoke Idaho 1918-16. The court must find that a fair and impartial jury cannot be impaneled in the county where the criminal complaint, information, or indictment was filed. 2, that it would be more economical to transport the jury than to transfer the pending action, and that justice would be served thereby. As explained in more, which in other words, get a jury from outside of Latah County and just bring them in. They're going to be sequestered, and that's it. They're there for the trial. That's cheaper than having to move this whole trial with the judge and the prosecution and all the evidence and paperwork and clerks and this and that, all 300 miles away, at least once a week. Because what, are they just going to live there for the next couple months? This whole team, the witnesses have to be flown in instead of just driving maybe half an hour to get to court. It's crazy. As explained in more detail in section 2 below, the transfer of trial to Ada County would come at an extraordinary cost. Transporting the jurors from neighboring counties such as Nez Perce County would be far more economical option. Similar in population size to Latah County, Nez Perce County has a population of over 42,000. United States Census Bureau data available at this, if you want to go and see it. Lewiston, the largest city in Nez Perce County, is approximately 30 miles from Latah County. So driving 30 miles each way, each day, is a lot better than 300 miles each way, right? 30 miles to the Latah County Courthouse. Summoning a jury panel from across the country line would incur far fewer costs and logistical issues than moving the trial to Ada County. Transferring venue would not be convenient for the parties and witnesses, nor would it be in the interest of justice. Defendant next argues that the court should change venue under Idaho Criminal 21B, which provides that upon defendant's motion, a court may change venue to another county for the convenience of parties and witnesses and in the interest of justice. This Idaho criminal rule addressing venue is distinguishable from its civil counterpart, Idaho Rules Civil Procedure 40.1, which also allows for a venue change for convenience, but is limited in scope to the convenience of the witnesses and the ends of justice. Defendant does not even address the convenience of the parties and has failed to establish that a change of venue in this case is convenient for the witnesses or in the interest of justice. I'd like to see one witness say, I want to travel 300 miles each way to testify. And if I have to testify over 2-3 days, I have to drive 6 hours each way every day until I'm done. Or I have to drive 300 miles, spend money on a motel room and everything else, you know, especially when you got people that are 911 operators who are police and stuff like that. Like Latah County doesn't have that many police to begin with. So to send somebody for a couple months to 300 miles away and house them, you know what I mean? And to house a judge and everything else for minimum 5 days a week, every week, and fly them back and forth. Oh gosh. Ooh. First, defendant argues that Ada County's large population size has more than 10 times many potential jurors than Latah County. Right. They've got a larger population. So Latah County, 80%, I think they said, of people surveyed in Latah County think that he's guilty, whereas 93% in Ada County think he's guilty. So if you go on percentage, Latah only has 42,000. So you've got, what, an eighth of the population that think he's guilty, which would be what, maybe 2,000 people, 3,000 people? Whereas if you take that same mathematical quotation and use it for a higher population in Ada County, you got like 15,000 that think he's guilty. Right? Pissing off the jury right from the start isn't a wise idea, right? Summer Dawn says, yeah, that's what I thought was weird. We name streets after people who have done something for our community. So why name a street after Ann Taylor? Is the street called Ann Taylor or is it just Taylor? Like, is the whole street named Ann Taylor? Or is it just the last name, Taylor? Oh, wow. Summer, let me know if you find anything different, because what I have read is Ann Taylor name was used back in the day for stores, streets, and even in movies. Really? Just says pissing off the jury right from start isn't why his idea. Well, they've called them stupid and impartial and can't put preconceived notions aside, that can't follow the law. What else have they basically, with what they've said, what else have they basically put in the jurors' minds regarding the way that the defense thinks about the people of Latah County, not just prospective jurors, the people of Latah County? They think they're stupid. They can't be impartial. They can't follow the law. What? Yeah. Yeah. Crazy, eh? Like I said, if I was a resident of Latah County, I would be livid. But then again, is that why she's saying this stuff, to piss them off even more? So she can say, look at how prejudiced they are. But you've made them that way. You made them that way with what you just said. She's prejudice against the people of Latah County just by what she said. Basically, if they say they can put their preconceived notions aside, it should be taken with a grain of salt. That means, like, don't believe them, because they're probably lying. So they're liars too. You know what I mean? Who else thinks that? Like, you're basically calling the residents of Latah County stupid, prejudiced, and liars. Right? Who agrees with that? You don't have to agree with me. That's the way I've just read this, by what the defense has said about the people of Latah County. And if they say they can put their preconceived notions aside, you got to take it basically with a grain of salt. So you're calling them liars. They're probably lying if they say they can do that. But the people of Ada County aren't like that at all. There's more of them that think that Bryan Kohberger is guilty. There's less people in Latah County that think he's guilty already than in Ada County. But you want to move to Ada County. There's a reason why you are wanting this trial to go to a community where more people think he's guilty. It's crazy. Make it make sense. So where were we? But the fact that Latah County is smaller than Ada County does not mean that it's too small to select a jury. As the 11th most populated county of Idaho's 44 counties, Latah County is larger than 75% of Idaho's counties. Latah County's jury-eligible population of over 32,500 could easily accommodate a panel of hundreds or even thousands of individuals being summoned for jury duty. Absolutely. But the defense always has is already prejudiced against them because of what they've already called them, saying they can't be impartial. They couldn't set their stuff aside. And even if they say they can, they're probably lying. As noted above, if the court were to proceed with a 12-person jury and 6 alternates, the court could easily summon 1,800 individuals. That's 5% of Latah County's total jury-eligible population. That's right. They didn't have, I think there was 1,000 jurors that were called for Chad Daybell. They went through 700 and something and picked a jury. So if you got easily 1,800, there's no way you can't select a jury out of that. So meaning that one of every 100 jurors called for duty, only one would need to qualify to be able to seat a jury. So say you call 100 a day over 10 days, only one each day would need to be chosen to select a jury. Next, defendant argues that Ada County Courthouse can best accommodate this trial, specifically Ada County's large courtrooms. See, that's why they said that. What page am I on? 17. That's why they said they used this way back here. Where is it? Here. Where the hell was that? Let me find it. Oh, here where they use Shepard versus Maxwell. Pretrial publicity is an issue and a presumption of prejudice. This is where they said that the media overtook the courtroom and had a room right beside the jurors, and the jurors had to walk through media and cameras and everything. Well, that's not what's happening in this case, but that's why they're saying this now. We were on page 17. Here we go. Defendant next argues that the court should change venue, which provides that upon defendant's motion, a court may change venue to another county for the convenience of parties and witnesses in the interest of justice. This Idaho criminal rule addressing venue is distinguished from its civil counterpart, Idaho Rule Civil Procedure, which also allows for a venue change for convenience, but is limited in scope to the convenience of the witnesses and ends of justice. Oh, I think we already read this, didn't we? I think we already read that. Okay. First defendant argues that he's got a large population. Okay, here. Next, the defendant argues that the Ada County Courthouse can best accommodate this trial, specifically Ada County's large courtrooms with adequate space for attorneys and room for spectators. What do you care more about? Having a fair trial or the size of the courtroom? Who cares what size? I don't care if it's the size of my kitchen. If the evidence can be presented, all that has to be there is the prosecution, the defense, the judge, the clerks, and a little bit of room for maybe spectators. The bottom of my house would be big enough to fit the judge, the prosecution, the defense, and tons of spectators. Stop it. And room for spectators. But even Ada County cannot accommodate, excuse me, every interested spectator. That's not their duty. This should not even be brought up as a reason to change venue. The reason to change venue is to get a fair and impartial trial, not how big the courtroom is, how many spectators can be in there, right? One merely had to drive by the Ada County Courthouse during certain days in the Lori Vallow trial of 2023 and the Chad Daybell trial earlier this year. There was hardly anybody at the Chad Daybell trial. If there was 25 people in the courtroom on any given day, he's lucky. There was more for Lori, but for Chad Daybell's trial, we watched it. There was so much emptiness in the spectator area. They were lucky to have 20 people there a day. And I don't think they even came near 20. When they did have a full courtroom is closing arguments. During closing arguments, the courtroom was full. But other than that, on a day-to-day, you were lucky to have 15, maybe 20 people. and it can sit 70, I think, or 75. You were lucky to have 15 to 20 spectators. Earlier this year to see the line out the door. Okay, this is stretching. The line out the door was there because the court only opened the doors to the spectators at a certain time. So everybody had to line up outside and wait to be let into the courthouse. That wasn't a line out the door because, oh my gosh, it's just overflowing. No, they had to wait outside until just before the case started, and then they were let into the courtroom. It's not like they were lined up out the door, down the hall, up the stairs, and around to the courtroom. No, they weren't even allowed in the courthouse until a certain time. That's why there was a line outside the door. The 15, 20 people that were there. I agree, Summer. See if that street is near the courthouse, or would it be on a major street around the courthouse? So this is crazy for her to even put that in there. The public interest in attending the Chad Daybell trial was so great that individuals who wished to attend had to apply online for a reservation the day before to get a ticket into the courtroom. Chad Daybell's trial would be live streamed. Here's what you need to know if you want to be in the courtroom. East Idaho News. Yeah. So what? You had to apply the day before. So what? On cases of such tremendous public interest, there is unlikely to be any physical courtroom large enough to accommodate every member of the public. Okay, who cares if it's big enough for every member of the public that want to go to get in? That's not your concern, Ann Taylor. Your concern should be getting a fair trial for your client, whether that be in a courtroom that's 15 feet wide by 20 feet long or 100 feet wide by 100 feet long. It doesn't matter. And that should not be one of your arguments. Because up to this point, Ann Taylor, you tried to keep quite a bit from the public. So don't pretend like you got the public's interest here. And that's not even a factor that you should be pushing for your client. It should be to get a fair trial and a fair and honest jury. This should not be of concern to you. What are you looking for, Anne? You want the spectacle of a large courtroom so all these cameras and everything are on you? Get the F out of here. And on top of that, for those of you who don't know, she has taken on a second death penalty case of a white supremacist. And I know here, if you're working for the defense or prosecutor, if you are working on a death penalty case, you don't get any other cases assigned to you. It's 24/7 on that case. She's taken on a second capital murder case. And apparently from what I'm hearing, I haven't been able to validate it yet, but what I am hearing is she left the prosecutor's office and she's in private practice now. This should not be a concern of hers if every member of the public who wishes to observe can get in. That's not your business or your concern, Ann Taylor. Your concern should be your client. Like, this just grandstanding is getting ridiculous. She's starting to remind me of what's her name from Vanderpump Rules. Oh, what's her name? Ariana. She got cheated on. Okay, it's a nasty thing. But she's grandstanding it, and the reactions to it is like she is the first person on earth to be cheated on. And he should be facing the firing squad for doing so. This is who Ann Taylor is reminding me of, is that chick from Vanderpump Rules. Disgusting. Moreover, the court can accommodate the large number of people who want to view the trial by providing live streaming options. As to the size of tables for the attorneys and the location of media and the daily workings of security, these logistical considerations can be addressed by carefully planning with the local trial court administrator or administrative district judge. There is no reason to think that the Latah County Courthouse or its staff is incapable of addressing these administrative and procedural matters. So what? What are you saying now, Ann Taylor? Okay, because this is what the prosecution is replying, right? What are you saying up here, Ann? You got dingy little courtrooms in Latah County, and there's not enough room for all my spectators to come and see my new dye job. Maybe she got a facelift. I don't know. But my client needs a big table. My client needs a big audience. Piss off, Ann Taylor. And now it's like she's taking shots at Latah County Courthouse. It's not good enough for her. It's not big enough. It's not this. And it does. It makes it seem like the courthouse staff in Latah County is incapable of doing their job. Like she could ruffle a lot of feathers here. Indeed, when the defendant filed a motion to remove cameras in the courtroom after media outlets repeatedly took up close-up photographs of the defendant in violation of a prior verbal admonition of the court swiftly denied multiple subsequent media requests and eventually issued its amended order governing courthouse and courtroom conduct, which prohibited the media from video recording, still photography, or audio recording during the court proceedings. More than capable of dealing with the controversy, right? Defendant's motion to remove cameras from the courtroom, August 24, 2023, amended order governing courthouse conduct, January 5th. There is no reason to believe that any subsequent concerns about media or security would not be addressed with similar efficiency. Like, so she's taking jabs at everybody. She's taking jabs at potential jurors. She's taking jabs at the people of Latah County. She's taking jabs at the courthouse staff. She's just a biatch. For entertainment purposes only, that's my opinion only. It's summer dawn. Well, back in 1902, when we used to have our microphones were made of straw, and we had that string between two cans. That's how we used to communicate. Oh, God. Defendant also argues this case should be moved to Ada County based on cost. Really? People should have to drive. Well, they wouldn't be driving. They would have to fly, because nobody's going to drive for 12 hours a day, 6 hours there and then 6 hours home. And 8 to 10 hours of court. Where do you sleep? Right? So they would have to fly them in. Defendant also argues this case should be moved for cost. That means the judge, all his court staff, the prosecution, all the defense, all the evidence, all the witnesses, all the family, everybody should have to go 300 miles away, pay for added costs for rental cars, for airfare, for accommodation, and time away from family. Like the judge, the court staff, the prosecution shouldn't be able to see their family at the end of the day because they got to be 300 miles away all week. Piss off, Ann Taylor. Just because you got nobody, get a life. Maybe you'll understand that others have lives too. Defendant's argument is limited to asserting that out-of-state witnesses who fly into Boise would be closer to the physical location of the courthouse, while Latah County witnesses would potentially have to fly to the Spokane airport and rent a car. The state does not dispute that the Spokane airport is further from the Latah County courthouse than the Boise airport is from the Ada County courthouse. However, the nearby city of Lewiston also has an airport serviced by Delta and United with nonstop flights to Denver, Seattle, Salt Lake City. Lewiston Airport website available. Go check it out. But whether out-of-state witnesses fly into Lewiston, Spokane, or even Boise, the cost of rental vehicles for a handful of out-of-state witnesses is only a fraction of the total cost picture. Most of the state witnesses are local to Latah, Moscow. Willow, you need a drink. I don't drink. Take one anyway. I don't have any. Okay, back to this. Most of the state's witnesses are local or will be traveling to Moscow by car. If venue is moved, those witnesses who are local would need to rent hotels in Boise, potentially for multiple nights while they wait to testify. The state's law enforcement agency, state's law enforcement and emergency dispatch witnesses would have to potentially be away from work for days rather than hours, creating a ripple effect of inconvenience. Similarly, the medical examiner who is based out of Spokane would also have to extend her time away from the office. Some witnesses who would otherwise drive to Moscow from Spokane or northern Idaho, the potato state, would have to obtain flights if the trial was moved to Boise, which would increase the costs. Back in 1902, they took the train or the horse and buggy. While defense counsel took this case on a contract basis, and will have to travel whether the trial is had in Ada or in Latah, the same is not true for the court. The court reporter, the court clerk, and the court staff attorney all would have to travel to Boise either by air or in a state vehicle, would have to obtain lodging, and would have to arrange for per diem reimbursement for meals. The state, which has a burden of proof and must deal with the logistics of juggling witnesses and trial exhibits, would have to relocate both of its lead attorneys as well as its support and victim services staff for weeks and likely months. This would come at a great expense for lodging, transportation, and per diem for meals. If you don't know what this means, that's for meals, and other things are also in there. Additionally, the elected prosecutor and his chief deputy would be physically away from the daily operations of the Latah County Prosecutor's Office and from the law enforcement agencies they advise, creating a potentially detrimental ripple effect for Latah County's public safety operations. Finally, the defense also asked the court to change venue on the basis that Moscow Police Chief Fry is currently running for Latah County Sheriff. First, the presupposes the outcome of the November election and is premature. What the frig does that have to do with anything? Chief Fry is currently running for Latah County Sheriff. So? I don't know. If elected as sheriff, Chief Fry would have the statutory authority to summon a sufficient number of trial jurors in the event that there is an unanticipated shortage. Defendant states that Chief Fry is a witness and therefore his duty would create a conflict. Well, what's the difference between if he's chief of police or if he's a sheriff? If you feel that there's a conflict between, because he's a legal representative, like he's law enforcement, he's still law enforcement. I don't know. At this time, the state does not anticipate calling Chief Fry as a witness. However, even if he were called as a witness by the defense, and even if there was an unanticipated shortage of jurors, he could delegate his authority to a senior chief deputy to exercise that function if necessary, allowing county officer to designate a senior deputy to perform the duties of the office during vacancy. The court should also consider, in the interest of justice, we're almost done, you guys, should also consider, in the interest of justice, the physical location of the victims' families. Interest of justice, a consideration in a court's determination whether to change venue for convenience. It is the state's understanding that most of the victims' immediate family members who are constitutionally entitled to attend trial proceedings live closer to Latah than to Boise. It is all, oh, what happened here? Did somebody go home for the weekend and then come back and change their font? Because this font is different than this font. This is bold and this is not. That's weird. It is also strange to the state that the surveyor did not do polling in geographically closer counties such as Nez Perce County. Given how close the overall prejudgment rates among the surveyed counties were, it is entirely possible that Nez Perce County could have had an even lower prejudgment rate than Latah County. So Latah County was way down there compared to Ada County. So why would they not have taken or pushed to keep it in Latah County? Because there was a lower rate of prejudgment in Latah County than there was in Ada County. It doesn't make sense. There's something about Ada County, you guys. You heard it here. If the court were to change venue, it seems to the state that changing venue to a geographically closer county such as Nez Perce or oh my God, you're testing me. Kootenai? We'll just say it fast and you guys will think I'm saying it right. Kootenai County, just across the state line from the Spokane International Airport, would be less inconvenient than moving the trial 300 miles south to Boise. Right? In any event, the defendant has come nowhere close to demonstrating that moving this trial to Boise, Idaho, would be convenient to the witnesses or the parties, nor has the defendant demonstrated such a move would be in the interest of justice. Defendant has failed to meet the burden. We're almost done, you guys. Defendant, I think this is the last page. Defendant has failed to meet his burden of showing that change of venue in this case is necessary or convenient. The court should decline his invitation to ignore well-settled precedent establishing the voir dire process. The court should also decline to relocate itself, the state, and the scores of witnesses hundreds of miles only to face another jury pool with similarly high media exposure. Defendant's motion should be denied. There you go. And this was submitted on the 12th of August. So there we have it, you guys. Oh, let me get my coffee out of there. And again, for those of you who are still here, any super chat of $5, we're going to go live on the 29th to cover this hearing that they're going to have for Bryan Kohberger. At the end of that hearing, I'm going to draw somebody's name, $5 to get your name on the wheel for the book. And this is going to be framed. I just finished it, so I haven't been able to frame it yet. But this will be in there also and framed. I will be sending that out to you too. Framed, of course. And the copy of When the Night Comes Falling, the Idaho Student Murders. So $5 gets your name on the wheel. We will also do that draw live right here at the end of the hearing on August 29th, which is next Thursday. So it's a good way to support the channel, and you get a chance to win the book by Howard Blum and this framed for $5. There you go. Summer says, I don't know if you saw or not, the courthouse is 15.3 miles from Ann Taylor Street. Interesting. These motions are so important. Don't understand why more care isn't taken in proofreading them, right? JJ almost didn't get justice because of a typo, right? Like, I hate that. There's nothing I hate more than documents being submitted into the record that have all kinds of mistakes in them. There was one that I seen, I think it was back in April. And instead of having April 2024, it had April 2023. And I haven't heard nothing of anybody saying anything about it in one of the court filings. It said April 2023 when it should have said April 2024. Kate Bell says BK's case is going to take 30 years, right? Like, is this ever going to get to trial? It seems like Ann Taylor like when you're working with a defense attorney and the defense has to work with the prosecution and they both have to work and do the judge, the court wants, and everybody equal rights type thing. You know what? Be kind and nice and give a little here because you'll get a little here. You know what I mean? Work together for the same outcome that everybody wants is a fair trial. But when you start taking pot shots at the abilities of the Latah County courthouse staff, you start taking pot shots at the people of Latah County. Well, even if they say they can put their own thoughts aside and just judge him on the evidence presented, don't believe them. Take it with a grain of salt. In other words, you're saying that they can't be honest and truthful, that they're liars. Like, you're taking pot shots, and that's not okay. And on top of that, she's taken on a second death penalty case. Okay, let me just see. Right? Yeah. Well, Anne is thinking everybody else is shady because she's shady. And it's like she's already complaining that she couldn't do this case this year because there's so much that she still has to go through. There's so much she still has to go over. Then why are you taking on a second death penalty case? You can't even go through all the evidence and disclosure that you got in this case, and you've taken on a second one. Like, what the F? And it's like, what Anne wants, Anne gets. That's her motto. What I want, I get. I'm special. She talks to the judge like she's his mother and she's scolding him, and he takes it. It's like, what? When she started raising her voice to him and over talking him in one of those hearings, it's like I was dumbfounded. Like, what is going on here? I have never seen a judge allow a defense attorney to interrupt and overtalk him and yell at him. Never in my 30 years of working in criminal law, I have never, ever seen a judge allow a defense attorney to treat the judge the way she does. I quote my grandmother, more on this channel than anywhere. Can't make chicken salad with chicken shit, right? Nina, the judge, yes. You sent it via PayPal, Kat? Okay, let me get you written down. I got the list. Where is it? Here it is. Mary Michael. Missy, Colleen, Nana, Josie, Cat H. Cat H. I got you written down, Cat. And this, Cat, I will have it all framed nicely. I just finished it, so let me just, you can see the sparkle in it. And this is one of the nicer ones with the eagle and the flag. I just love it. I'm going to order it again because I want one for myself too. I know I live in Canada, but honest to God, I love the American flag. I love the American flag. Like, I'll show you. Hang on. Oh. You guys want to see my favoriteest sweatshirt? My favoriteest sweatshirt. You want to see it? Who wants to see it? Who wants to see my favoriteest sweatshirt? I've missed the lives due to my work. Summer, I've missed the lives due to my work schedule. Does the 5 only count on lives? Well, during the lives, or if you use the super thanks, the little heart below the videos, you can donate there too. You can donate via PayPal. I just found it was much easier for people to donate during the lives because they can just click on the button there. But Kat just donated through PayPal, so. Okay, you guys want to see it? Yes, mine is your yellow one. I only see the sleeves, but love the color. You haven't seen the sleeves yet. This is one sleeve. Okay, hang on. Okay. That's on one of the sleeves. Okay. This is on the front. This is on the front. And this is on the other sleeve. We the people. Hollister's, we the people. American made. So this is my favorite sweatshirt. And it's favorite because it says, I love this sweatshirt. But yeah, it has the American flag and it has the American eagle. I just love it. And it costed me, I think, $120. Because, before you guys say, well, no, they're only $79 or $69 on the site. That's American. I had to pay Canadian plus the shipping. It was like $28 for shipping, American. So you got the $69.99 for the sweatshirt, $28 for shipping, and then I had to pay duty because anything valued $50 or more at the border, I have to pay duty on it. So I think it was $11 in duty. I love it. The same as I bought 2 sweatshirts from oh, here we go. This is the brain farts. This happens once you hit 60, you guys. Oh my gosh. Hang on. Oh. This guy. Or 2 of his sweatshirts. Each sweatshirt cost me $155 Canadian. That's the sweatshirt and the shipping and duty. I swear to God, I still cannot, it's not, his name's not coming to me. So there's only a few creators that I have bought merch from, and it's only because of the cost. CJ Faison, that's him, CJ. I bought 2 of his sweatshirts, 3 actually, 3 sweatshirts. And it's because it ends up costing me like $150 Canadian each one. So what, almost $400 for 3 sweatshirts that I bought. But I like them, so, and I don't mind supporting good creators, so it's difficult. The same as Diamond Art Club. I love a lot of their paintings, but there's a painting that I actually just ordered. I ordered a painting and it said it was $39.99 American, and then I ordered another tip for my diamond painting pen, which was $22 plus shipping. My order came to $122 Canadian. It's crazy because then I got to pay duty at the duty thing too when it comes across the border. Anything over $50, I got to pay duty. So $39.99 for the American, which ends up being $67 for some reason Canadian. When you change it to Canadian funds, that $39.99 painting is now $67 Canadian. That's with taxes and everything else. It's crazy. These ones here I got from Temu. And it's really good quality. Like I've done probably about, this is one of the smaller ones that I do. I've got another one I just finished that is like 2.5 feet long by 1.5 feet wide. I just finished that. It's huge. Let me grab it. Hang on. I'll have to show it to you a little bit, because it won't even all fit on here. But this one here, it's a foot and, I can't, I'm going to knock over everything. See, look at how wide it is. It's 1.5 feet wide by 2.5 feet long. I just finished this one. I'm trying to get most of it in here, but I can't. Anyway, I just finished that one. That one also I got from, that one too, I also, the big one I just showed you, I think I paid $8.99 for it from Temu. To buy that on Diamond Art Club, they got something similar to it. They wanted $122 American. So that was nice, eh? Yep. I've only had, oh my God, I've probably bought about 60 diamond paintings. I swear to God, I got a whole box of them over there. Probably about 60 diamond paintings I've bought through Temu, because a lot of them I'll wait until it's like 50% off. So like a $10 painting I'll get for $5. So when I get that bonus that everything I buy is 50% off, I buy a whole whack of diamond paintings. So I've got a stash. And out of those 60, I think I've had 2 that were crap. Like one was a square diamond painting and the diamonds wouldn't stick. So I had to go and buy, I think for like $6, $7, I just bought this. And before you put your diamonds down, you just put this all over top and paint it out, paint it on top, do another one, paint it on top, and let it sit for a day. And then it's tacky enough that the diamonds will stick. So I was able to save that one. And it was my big owl one that I did. So I was able to save that one. But the other one, it wasn't the poured glue. It was like the 2-sided tape. And it was all crumpled up and big bubbles and holes in it. It was garbage. But I think I only paid $4 or $5 for it. So I just tossed it. But the savings compared to the bigger companies, it's pretty good. And I've only had really one that was garbage. The other one I was able to fix for a low cost. So, and it turned out beautifully. So, but then I go out and I either make my own frames, but this one I think I will, I don't know if I'm going to make the frame or if I might have one that will fit it. I don't know. We'll see. But generally I just make my frames. But anyway, you guys, so this is what's going to be drawn for on August 29th. So as soon as we're done with the Bryan Kohberger hearing next Thursday, not this Thursday coming, the following Thursday, August 29th, it starts at 9 a.m. Idaho time. So I think they're 3 hours behind me. So it'll be like noon Eastern. They're going to be discussing the change of venue, and I think there's a couple of other motions too to hear. I'm still waiting, you guys, to hear about the decision that the judge in the Karen Reed case, if she's going to haul these jurors back in to see if they had reached a verdict or not. We don't know what's going to happen yet. And that was on the 9th. So here we are going on 2 weeks later, and she still has not come back with her answer or her judgment or her order. After they argued, each side argued why the defense argued that counts 1 and 3 should be dropped because the jurors obviously came back with not guilty verdicts on them. They didn't understand that they could say not guilty to some and guilty of another, or hung on another and not guilty or guilty. You know what I mean? So, and the prosecution fought against it. So they got their oral arguments in and the judge took it under advisement. We're still waiting for the judge to come back with her decision. If she doesn't, Boston will implode. Yeah. Did you see the ballerina trial verdict? It was sent to the slammer? Yes. And I'm still kind of, I thought to myself, she looks really smug. She looks entitled. She looks unfazed. I didn't like her demeanor in court at all. But I believe that it should have been self-defense. When you're faced with certain things, I don't want to get into how I know this, but if you guys trust me, you can take my word that I know for a fact that you can endure a lot before you finally snap. And it's not like, how can I say this? It's like you take abuse, you take abuse, you take abuse. Abuse comes in many forms: financial, emotional, verbal, all kinds of abuse. And I have found that somebody that is constantly taking abuse and abuse and abuse and abuse and abuse, and how they appease their abuser just to save arguments, just to have just a little bit of happiness, or search for that little bit of who I thought that person was, and then have close calls where he could have really hurt me, and then he does lash out. I can see where her mind click, it's me or him. I see it. And whether you want to believe me or not, I can say firsthand that if I had had a weapon, my ex probably would not be walking the earth. And I'm not saying I would go searching for him now. This happened 10 years ago. But in self-defense, I probably would have done the same thing because I knew what was coming. But I didn't have a weapon. And if it wasn't for, I have in my 3rd degree black belt, and if it wasn't for that, I would not be here. And I had to hurt him, short of, maiming him or anything, but I hurt him bad enough. And this guy was, almost 6 foot and almost 300 pounds. And I was like 98 pounds soaking wet. And he had me bent over a table, choking me. And I couldn't breathe. And it was like, it was me or him at that point. So I know, I feel her pain, and I feel how it got to that point where she was finally, it's me or him. So I don't know. I think that, I don't know. And I did a lot of the same things she did, trying to appease him, act happy, because if you didn't, you just got it worse. Especially when you own property together and stuff like that. I'm still paying financially for that fat bastard. I'm still paying financially because he screwed me so bad financially. And for the first couple of years after I left, it wasn't easy. With everything I had to pay, I had houses to pay for, and anyway, a business that the government, oh my God, because everything was under my name, my business name, and he screwed a lot of people. The Port Authority, suppliers, which costed me tens of thousands of dollars. So, I mean, I get it. But I didn't like her. I didn't like her at all. I thought that she sat there really smug. But I don't know. Yeah, it does. It takes your humanity. Okay, Nana, you take care, hon. So it's hard to judge someone when you haven't been put in a position like that. Was it planned? I don't know. I don't think the prosecution proved that it was planned, premeditated. Was it self-defense? It's in the eye of the beholder. I think it could have been presented a lot better. I think the witnesses, the expert witnesses that she needed, she didn't have. So that's just my opinion. I know it's not popular opinion, but I think, I don't know what she was, I don't know, what was she found, what did she get? Did she get a manslaughter? I don't even know how many years she got. Okay, thank you, Summer. Anyway. Okay, so the next hearing, you guys, is August 29th. It's going to be around 11:30 a.m. Second degree. No, see, no. I don't think, if she got second degree, I totally disagree with that. Maybe in manslaughter, give her 5 years for taking a life, because I don't think anybody's life should be taken. But if she felt like my situation was different from hers, because he was choking me. Like I wouldn't be sitting here today if I didn't do what I did. And I didn't stab him or anything like that. I used my, I don't even want to say anything. Anyway, I think she should have got manslaughter, maybe 5 years, because he didn't have his hands on her. Now, if he would have came closer to her and kept coming closer to her, yes, shoot him, because it stands your ground there, right? You have a right to defend yourself. If he was coming at her like in the way that she said that he was, it didn't even look like him and this and that, I would have waited. I don't know. I can't say that, because I don't know how I would have reacted knowing what he did to me in the past. But I don't know. That one was a tough one. I couldn't watch it all, because it was a tough one. And if she lied, she needs a Golden Globe or Grammy or whatever for Best Actress. But manslaughter. Yeah, give her 5 years. I think I would have waited until he was like within a foot or so of me before taking a shot to end somebody's life. Like, okay, you have every intentions of coming at me. I'm done. Especially when you see I have a weapon and you still continue to come at me. I don't think he continued to come at her when he seen the weapon. I think he was turning to get the fuck out of there. Like, oh shit. That's what I think. And she shot. Because it got him in the right side, right? Somewhere in his right side or something like that. Up to 30 years? Wow. That's crazy. Now, if I personally think that she was in fear for her life, but I think when he crashed open that door, I think she was already there waiting for it. Like, and it's like when he seen that she had the poo-poo, I think he tried to turn around to get the fuck out of there. But he had already grabbed her and slapped her at the door, right? when she tried to leave. Where the F are you going? She ran to the bedroom. She got her pew-pew. Why was there still a pew-pew in I don't know. But anyway, she grabbed the pew-pew. He busts through or swings open that door. And even if he was yelling and screaming at her, as soon as he seen that gun, I think he went to turn around to leave. But in her eyes, it was like, oh my God, he's coming at me. Boom. Whereas myself, I think, like in my head, I think because there was, I think, what they say, 10 feet, 15 feet. She was up against that wall by the window, by the mattress, and the door was over here. Now, as far as I'm concerned, from what I understood, is he came in that door, smashed open the door, kicked open the door, whatever he did. I think he's seen her with that pew-pew, and he turned around to try and get the hell out of there. But she already had the pew-pew, and he booted open that door, and in he came. She just fired. I think myself, I would have, as soon as he seen the gun, if he didn't turn around to book it and still kept coming towards me, then I would have fired. But I do believe that he busted through the door and turned as soon as he seen that gun, and he was going to book it. She said he came at her still. There's no way of knowing exactly what happened there, except for one's not with us anymore, and the other one is claiming self-defense, that he still came at her. Did he? We don't know. Yeah, it sounded like she had enough. That's what it seemed like, yes, on the side and one in the leg. Now, there was only two. There was the one in the leg and the one in the upper torso. Another one missed and went into the wall because they found it, that it went through her wall, through the bathroom, and lodged in the bottom frame. I watched that part. That one didn't hit nobody. There's one that hit him in the leg and one that, like, did she fire twice? Did she fire one that he went backwards, his feet up in the air, and then fired again and got him in the leg? I don't know. Or did she fire and hit him in the leg, and he still kept coming at her? So she fired to the torso. I don't know. We weren't there. And nothing came out to prove which shot was fired first. They said that they couldn't prove which shot was fired first. But I would assume, to me, it looks like the leg shot was fired first. But it doesn't make any sense because in order to hit the way it hit, his leg would have had to be up in the air. Like, did she fire a warning shot at the wall first and then him come at her? So she fired in the chest and then fired another one. I don't know. Why was that shot fired? Like, she hit him twice. Why did she miss that other shot? Was that a warning shot? Get the F away from me. Because it went like to the left of him, like the door. Here's the door. She fired down here, right? And it went through that closet, through the bathroom was on the other side of that wall. So it went through her closet, the bathroom, and landed in the baseboard out in the hallway, right? So if she fired a warning shot, did he then lunge at her? And that's when she shot like twice, once getting him, which probably propelled him backwards. His feet go up in the air and shoot again. I don't know. If anyone's in an abusive relationship, please make a plan. Yeah. And do not ever leave when it's just you and them. Always have somebody with you. And see, that was kind of like another thing. It's like, why would you send your mother away? Why would you let your mother go to the park with your daughter if you were afraid of him? I don't know. Yep, the most dangerous time is when you're leaving. Did she lead him on a bit? I think so. Was it to appease him or was it for other reasons? We'll never know. We'll never know because he's not here to tell the other side. We can go by some of the messages that they have, but that's not the full story. That's never the full story. And my ex was very manipulative. Like everybody else, it's like, oh my God, he's such a good guy. Yeah. Why is he a good guy? Well, he helped me fix my truck. He helped me build my gazebo. He helped me do my roof. Yeah. He's doing things for you. He's buying your trust. He's buying your respect. Anyway, I don't even want to talk about that anymore. It's well and far behind me, thank God. Thank the good Lord. Oh, Kate Bell, 100%. 100%. And it's not just women who are abused. There's men too that are abused. Believe me, I've seen it. I've seen it one too many times. It's just, I don't think men report it as much because of their masculinity. But I've seen some guys that take beatings that, oh my gosh, you wouldn't believe a woman did that to somebody. And they were able to do it because the guy just sat there like, this is a gentleman. This is a real man that even when being beaten on refuses to lay a hand on a woman, which is totally wrong. But there was this one case that we had, I'm going back about 15, 16 years ago. And she beat him with cast iron frying pans, baseball bats, golf clubs, you name it. This guy was beaten from head to toe and still never laid a hand on her. And the last time it happened, one of the neighbors had finally got fed up listening to the fighting and arguing and called the cops. And the cops come in just after she whacked him in the jaw with a golf club, broke his jaw, broke all his teeth, broke his cheekbone, his jaw. It was his face was all busted open. And that's when she was finally charged. And then they went into his medical records. That's how it ended up coming out. But this guy constantly had bruises, a cut lip, a black eye, and he always had an excuse for it because he just didn't want to admit that he was being abused by a woman. Yep. And it's whether it's a male or a female, because I'm not biased by any means, and I do feel like there's a lot of men out there that it goes unnoticed, not unnoticed, but they don't report for whatever their reason. I feel like people who have been severely, and I mean severely abused, their whole outlook on the world, on relationships, on morals and values changes. And it's like, I don't trust nobody. There's a handful of people I trust. Like, and you're very hyper alert after you get out of a really abusive, like a severely abusive relationship. You're on high alert at all times. And even now, I've been away from him now just over 10 years. And it's like high alert. Like you say one thing, like my ex used to say, it's get the fuck out of my face. Go away. I won't date. I won't date. Nope. I don't have time for it. It was just like to go through, or even the thought of trusting somebody like that again, no, I'm done. I'm done. I would never wish that on my worst enemy. Ever. And I swear to God, my guardian angel is my husband that was murdered back in 94. And I swear to God, if he wasn't my guardian angel, I wouldn't be alive today. I look back at some of the things and it's like, how the hell did I survive that? But it's everything about you changes. And it's like, I got a very low tolerance for bullshit. Like any kind of disrespect, it's like, immediately I call you out on it. Like I have no problem washing my hands of anybody, family included. And I have washed my hands of certain family members. Just because I don't want the drama, I don't want the bullshit, I don't need the lies. No. Look, at my age, I'm 60 years old now. Like, no, that's not what I'm dealing with the rest of the time I have on this earth, no matter how short or long that may be. I would rather be by myself and never have to deal with that kind of shit ever again than be with somebody who I've always got to question or wonder. You know what I mean? No, it's too stressful. Too stressful. So look what I do. I'm retired now. And basically, I do this now. Like I've always done my readings and stuff, but now I'm doing more of it. And I'm going online and doing it and stuff like that, which I never would have done in the past because I just didn't have time. I was running 2 businesses, house to take care of, tenants to take care of, fighting the government for stuff that I don't know that my ex still owes from 10 years ago. I got way too much on my plate. So when I retired, then I just did this full time. It's like, I'm retired. I do this. So that's why I can peer into things a little deeper on, especially like documents and stuff like that. It's because after doing it for so many years, it doesn't matter where you live. When you're writing up motions and stuff like that, number one, go through it 10 times if you have to before you file it into the continuing record. You know, like I'm more picky now than I've ever been because I think I got too much time on my hands. I'm so used to 3-4 hours a night sleeping to get up, go to work, get things going with, 2 different businesses, or doing my daily things that I have to do in my personal life and taking care of kids and grandkids and this and that. So now I've got a little bit of a break there because I'm now retired and I just do the YouTube. I do the private reads and personal life stuff, doctor stuff. Do you want to Yeah, why not? Okay. Okay, there we go. Well, thank you. You can thank Des. She's the one that got me really going. I thought at first I was just going to cover some cases that I was drawn to. But then I forget who it was. I think it was one of my neighbors that's like, oh my God, you got to do a read. Put it on YouTube. And it just took off. So it's like, okay. So that's how I got doing the reads on YouTube, was just basically all I was going to do was do reads on cases that I came across, right? Or that people asked me to do. And then I got tons of people wanting private reads. And then I got doing the mini reads and stuff like that. I still do the reads at my home. I still got a pretty good clientele that, come to me or I go to them. In like real life here. I'm not saying this isn't real life, but you know what I mean? Outside of YouTube. And then I do this on YouTube too. So it's good. That's what I say too. I'm retired. Leave me alone. Yep. K-Pal. I love it. I just got very little patience for bullshit or piddly stuff or petty stuff or somebody who's going to look at you and lie to your face. It's like I used to just let it go. Now I call you out on it right away. I don't give a shit. You know, you don't want to be called out. Don't lie to me. But it's, yeah. It's like, you're so mean now. No, I'm not. If I'm mean to you, there's a reason. If I cut you off, you handed me the scissors. And like I said, I don't care if it's family, friends. I don't care who it is. Like, I don't disrespect anybody. I don't treat anybody with disrespect. Even if your values are different than mine, you're entitled to yours. I'm entitled to mine. You know, I don't judge people because I don't want to be judged. But, you know, if I'm good to you and you come at me, it's like, or you lie to me or stuff like that. No, bye. I found you from the Gabby Petito Ancestor read. Oh, that was legendary. Yeah. Yep. I think the one that's right in line with the Gabby Petito for legendary is the December 6th read I did on the Idaho fire case when I asked about, is there an arrest coming? And tell me about the perpetrator. And it described Bryan Kohberger to a T. And that was on December 6th, 3 weeks before we ever heard Bryan Kohberger's name. I described him to a T. So there, I think that one, and there was another one too, way back. Oh gosh, what was her name? The blonde-haired girl that went for a jog and her neighbor out in farmland, and the neighbor guy, Quaker, whatever his name is, killed her. That one too. You know what? Well, I got a new neighbor. The house next door sold, and I got a new neighbor. I'd say it's been about 5 months now, and she's very timid sometimes. And her dog just had puppies. But anyway, she got to talking. We got to talk and everything. And I don't have any pets, so I went and I bought a bag of treats for the dog, the bacon strips and this and that and whatever. And I was there when her puppies were born, and it's just like, she's just good people all around. You know what I mean? So much better than what was there. I tell you that. And she says, you're just so easy to talk to. And it's like, oh, thanks, you know. But I have my limits. Like I can be your best friend or your worst nightmare. It's like the old me is sleeping, not dead. Sutherland, was that her name? Sydney Sutherland, that case. I did the read the day before they found her, and it was spot on. Sydney Sutherland. I think that was her name. And it's like, right down to, this is somebody she knows from high school or what, I forget what it was now, but everything was spot on. Yeah, she was a nurse, eh? Yeah. Very pretty girl. Very pretty girl. Like, she was so out of this guy's league. So out of his league. Like, she was somebody he would never, ever have a chance with. Like, on any level. But yeah. And that one came out, I think, the day before they found her. And, yeah, scary, eerie. And there was another one that it's in the community tab, Ira. One of the family members has been reaching out, And she says, oh my God, well, like when I go back to your reads from 3 years ago, because he was just found a week or so ago. And she says, I've gone back and watched your reads. And she says, oh my God, everything was right there in your reads 3 years ago. So it's nice, you know, like I've had quite a few that it's happened. I've been wrong on a few. Not perfect, far from it. Believe me, far from it. But there are ones that more often than not that it's like everything's there. It's just it hasn't come to light yet. Yeah, she was. Kat says she was a nurse. Yeah, she was gorgeous. She was very pretty. The same as what was the other one there? The mom of five that went hiking in the park and he took her life and he was wanted out of California and that one too. Yeah, he looked like she was so out of his league, so out of his league. Yeah, the Bryan Kohberger one, December 6th. I think I pinned that one too. But you go back and you watch that one, Arrest Coming Soon or something like that. And in that read, it was on December 6th. And I said, they have something. They have something to nail him. They just aren't telling us yet. Well, that was the knife sheet with his DNA. They were waiting for the results of the DNA and to figure out that DNA. And I described that he was a professor or something. He lectured, that he was from Washington, from that university area. I got that down to almost a T. Rachel Morey, yes, that's her. Her too. She was a very pretty girl. And they've got him too. He's been arrested. Yeah, Rachel Morey. And these girls are so out of these guys' league, you know, like, and look at the kids, you know, Rachel's kids that now have to grow up without, I think she had what, maybe five kids or something. So that case was really heart-wrenching. But they have arrested him too. I just seen a video come up in my feed regarding that they did catch him. And they got him in a bar. TIR. What's TIR? What's TIR? Cat. I wonder. As we're sitting here just chit-chatting. Oh yeah, I could put it in this frame. So I'd have to trim it out. It fits perfect this way, but on the sides I'd have to put some black, like almost like a black cardboard like this. This is too big. Or I'd put it in a bigger frame. But yeah. I've got some of this cardboard where I make the frame out like this to put over top. This is like just the right size this way, but this way. I suppose I could, yeah. I could probably put it in a frame. Just, yeah, I could do a black one like this. Or maybe I'll use the white. I don't know if the white, I think black would show up the lighter colors better. Because if you put white around it, I feel like it's taking away from this. Whereas if you put black, let's just see what black. Which ones do you think is better, the black or the white? Like just pretend this is the framing around it. How can I cover that? I don't know. See how the black makes this stand out a lot more? What do you guys think? A black framing around it or a white framing around it? Just pretend the white's over to here. What do you think? The black or the white? What do you guys think? Black or white? This would have to be evenly spaced around it. You know what I mean? Should it be black here? This part here? Or white? I need your all's opinion. I think the black makes it stand out more than the white. See if you got the black up against there. I think the black makes the white and the reds pop more than the white does. Black looks good. So I'll have to do one of these in black and make sure it fits this. So these are just frames. But I would either use the glass or whatever. I got a whole bunch of frames. So I'll be doing that, framing this up as well with the book. I've got it a little bent from shoving it in my cupboard over here. But black or even a natural wood. Yeah. I don't know. We'll have to see. I think the lighter colors, because there's light colors on the outside here, I think it just fades in. So I think the darker colors would be better too. I'll figure it out. I'll make a black one and a white one. See, I'm shoving it back in that cabinet again, and it's going to get all banged up on the top. But I'll try it with black and white and see which one looks better, which makes it pop, because it really sparkles. It's got a good sparkle to it. So, but yeah. So with that, you guys, I'm going to thank you all for being here. Going to wrap it up. And we're going to end it like we always do. Please take care of yourselves. Please stay safe. We will be back here on the 29th. Well, I'll be back here this Sunday with the mini reads. So if you do want your very own mini reads, Sundays at 1 p.m. Eastern, we're going to wrap it up. And then on the 29th, we have the Bryan Kohberger hearing. And then we will have the live draw for the book and the diamond painting at the end of the hearing. We'll do that live so you guys can see it live. So please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. Bye-bye for now.